Right. I mean, even in Delhi, for that matter, or all everywhere. I mean,
I think
the
most places.
outhouses were the offices for the councils.
They
But
have the basement.
yeah, but
They have the basement offices.
now, yes, right. And but with the staff increasing, with it becoming all the more challenging, most of the lawyers are now basically operating out of different premises than the residence. We'll start at 11, right, Ashish?
Yes, sir.
So just give me 2 minutes. I just need to fetch some water to drink for myself. Just okay.
Sure.
Yeah. Thank you.
I think from Monday we'll have some work opened up. We're just working on it. You can start. I think some norms will come out soon for lawyers' offices where, if possible, you are not in a containment zone. They are looking at a possibility whether to open up 1/3 of the people to work in some form, give a number of passes and allow them to move. That will be good. It will help us also.
But I think in Bangalore, in Karnataka, they are allowed. So the lawyers are allowed down there. I think we here also, but as you say, with the precautions.
I would typically feel if you're already living in the same zone, moving internally and not a containment zone, they should allow you to move to your office. Like what Mr. Batra said, his home and house are close by. So those kind of places which are not part of the house but offices, they should allow us to move, I think.
Well, yes. To us, I think the within the red zone also you are allowed. The only thing is that you'll have to use your own transport because public transport is still not accessible. Cabs also can come in, but not more than 2 people besides the driver, even for the private cab. In pillion riding is not permitted, so the staff that comes for motorcycle, scooter, they obviously won't be able to carry a passenger. So and 33% limits, which means almost like 3 people to 10 people. So firms is going to be a bit challenging to operate at any level with that kind of stuff, but at least we will be able to make some progress towards normalcy. Yes,
we made a move at least.
That's right.
Mr. Bhatta, can you just excuse me for a minute?
Yes, please.
Once you're back, we'll go live, sir.
Yeah.
Back, we'll go live, sir.
Another 1 minute, I should be back.
Oh, yeah.
Sir, there is one more screen coming with your name on it, sir.
My screen?
No, not in your screen, sir. Kalyan, sir.
Yeah, there's one more screen coming. So are you logged in from phone as well?
Yeah, I think so. There's some issue going on. Kalyan, sir, can you
just one
maybe
minute.
Is he using the audio of the phone and the video of the laptop maybe?
I think that's the both will have to come through the computer link.
No. It's still there?
Still there.
Continues to show, sir.
Says it's still there. Maybe we logged in from a different thing ID there. Yeah.
Yeah, I think we switched up this
Sir, Kalyan, sir, is your audio coming through, sir? Are you able to hear me, sir?
You're talking to me?
No, I'm talking to Kalyan, sir. Sir, is your audio coming through, sir? Are you able to hear me?
Yeah, now I'm able to hear you through.
So I'm going to remove this from the screen, sir. I have the option of removing it from the screen. So I'll remove it from the screen, sir.
Just try that.
Now, are you able to hear me, sir?
Yeah.
Yeah. Okay. So
Yeah, that's fine.
I'm going to broadcast this now. It's 11 o'clock, 10:58 rather. I'll go live now, sir. Attendees will start coming in, sir, now. 11 o'clock sharp, we'll start.
The other team members have logged in.
Yes, sir.
It's not logging in.
Ma'am, good morning, my Aman, Mr. Kaya, sir.
Sir, it's 11, sir. We can start, sir.
I just texted you.
Kalyan, sir, we can start, sir. It's 11.
Okay. Good morning to all of you. Welcome to the one more seminar of Surana and Surana International Attorneys. Today we have two eminent speakers who would be over here. And when I think about the insolvency practice and the company law, I'm only reminded of an incident that took place. What Vijay Merchant once said when he had to give the introductory speech about the speaker, Nani Palkiwala, who often would give the speech once the budget was given. And his speech was, I have a pleasant task of introducing the speakers. His name is Nani. He needs no introduction, and he sat down. It is almost in the similar vein that I can make this statement that the two speakers here today, Mr. Suman Batra and Mr. Arvind Pandyan, are well known in the legal profession. And just to give a brief background, Mr. Suman had started his practice in '89 and is currently in charge of Kesadas, a full-service commercial and litigation firm. He's been a consultant for IMF, World Bank Group, and various other nations on policy matters, both in the African, East European, Middle East, and Southeast Asia. He's been ranked in the Legal 500. He has been a part of the insolvency law code itself when it came in. So he's fully aware of the nuances under which it had been formed and the current changes that have been brought about because of COVID-19. He's an apt speaker. He not only does have interest in law, he's equally versatile. And I can rightly say that we have from the heights of the Himalayas, where he has a wonderful hotel running, to the plains of and the oceans of India in the south, where Mr. Arvind Pandyan hails from. We have the entire spectrum of India covered, speaking about this. Mr. Batra has been a judge in the moot courts conducted by Surana Surana along with the other law firms, and has known him very well. So welcome you, sir. As far as Arvind Pandyan sir is concerned, He too is a well-known person in these legal circles here, has been practicing for the last several decades. Both the speakers are authors, have written books, and are well versed in the subject. Just to speak about Sumant Batra, which was a point I should mention, he was one of the youngest INSOL International, a worldwide federation of association of accountants and lawyers. And with this, and without any much more ado, I hand over the proceedings to them to take it forward. Welcome, sir.
Thank you.
Welcome, sir. So that was a great introduction by Mr. Kalyan. I would request Arvind sir to go first, and thereafter followed up by the insights of
A very good morning to one and all. Mr. Kalyan, Mr. Sumant, Ashish, it's my privilege, I think, to make this virtual meeting into a formal one too by first giving my good wishes to all the co-speakers, the organizers, and to Surana and Surana in particular, and all other participants today. Now, I think it's going to be a great Saturday. I'm absolutely sure what Mr. Batra is going to bring will surely add a lot to our own understanding about both the law as well as the practice of IBC or connected laws insofar as our area, which is southern India, particularly the Chennai region, is concerned. We are lucky also, in fact, that just now the NCLT has also posted one more new member from Bombay. So as and when we have the bench starting, we would at least hope that 2 benches will now be full-fledged there. How we start, when we start is another question, but at least now we are ready. Bearing that in mind, we have had an understanding how to deal with the subject today. Ashish, as he gave each of us some preliminary minutes to introduce our thoughts on what we feel, and then get into the topic with the specific pointer questions too. All of us are sitting at home or in another place where we are right now indoors. Very rarely we are outdoors, I would say. Nature has got its own way of putting us into this box, as what we may call. IBC itself was a Indianized thinking out of the box, I would like to put it that way. The single most achievement, which I have been consistently calling the government's effort, if at all from 14 to 19, was bringing this IBC on 15/12/2016. And that, I think, changed the whole canvas of not just the practice, but the outlook towards credit repayment, payments, and the behavior. It's like how the saying goes, anything is very hard in the beginning, messy in the middle, and then gorgeous at the end. Actually, IBC really was kind of messy even at the beginning, not just hard. Hard and messy was an ordinary word. People may call it still continuing. But then it brought about huge amounts of some restructuring which happened over the last 2-3 years. We did see many Supreme Court judgments, many NCLT judgments, and also the commercial restructuring which have happened. I just would not like to link both these together, meaning the present pandemic with IBC, but would just like to also consider how it was in maybe 1933-34 when the Great Depression had happened. The Great Depression seems to have given birth firstly to the SEC, the Securities Exchange Commission, which came into existence sometime in 34. But the American experience is always not an Indian experience. I always am an advocate who say that never compare a developed economy with a developing or an underdeveloped one. We have moved from underdeveloped one to a developed one, or rather a developing one. So we can take some pointers from US, but tailor make it for our I would say, experience and requirement. Now that brought about a huge change, mainly because Americans never have even seen such a epidemic at that point in time, and so they were never prepared. But now we can't say about it, because after that then came the World War, and the one immediate thing which could I could at least relate to would be the 2008 subprime lending crisis, which also was only a financial crisis, but brought about by certain, I would say, factors, but which had a international impact. The point I'm trying to make is, at none of these times, the regulators or even the authorities or the governments never tried to tinker too much with the existing legal provisions or legal, I would say, the practices which are prevailing at that point in time, except to tweak and address something which has happened, but never what will happen. That's my understanding. Maybe Mr. Batra will add to it. So we are looking at something where the past, and as they use the word past, always comes from history. So except for the word called pandemic instead of epidemic, we're almost technologically savvy now, capable of continuing our work in some form, rather than being a complete static economy compared to before. We have had certain categories exempted as essential services and we're able to continue, but still the whole economy being brought to a grinding halt in various other forms. I still can't imagine when the social gathering places, this word social has a huge impact, according to me. When the earliest sayings went, that man is a social animal, then we also had social media, which has taken over the whole process now. And now we want to impose what is called a social distancing. So the social impact, again, the word social, seems to play a huge role. So you're not going to have many weddings where you're going to sit down together. So which means, are the wedding halls going to have business or not? You're not going to have too many hotels or places where you gather, starting off too fast. So this is something which is more industry specific, and legal specific. We are only a small spectrum of it. We always address the issue and we can never find a redressal for the issue. Whenever it happens, we address it. That's how law has been. So are we ready to immediately address it? According to me, no, because with the change in the epidemic to pandemic and with the change in the social structure, with social media also being there, and right now all of us being virtual, can there be certain sectors which, apart from being affected, which are slightly visible? But I would like to kind of give my one or two concluding remarks in the initial stage by saying that except for certain presumptions which we have, we should wait for the, I would say, at least beginning of normalcy. I won't even say when normalcy actually takes place. We are told different kinds of timelines of 1 year, 2 years, few months, or whatever. So until all the so-called red, orange, and green zones vanish and we find the whole country together, how do we kind of march, or I would say crawl slowly back to normalcy is what matters, and we should take it as it comes. So at the moment, I feel that IBC is the best one, which I will be addressing maybe in the next 1 or 2 buckets also, which I have planned. With the past experience, we should try to wait, watch, and then only act or react are my initial thoughts. Yes, Ashish.
Yes, sir. You've given us an insight on how it has played out in the past. I request Suman sir to add in on these.
Yeah, thank you, Ashish. Thank you so much, first of all, Kalyanji, for a very generous introduction. Appreciate very much. I'm humbled. And thank you so much, Surana, for inviting me to share my views, and Mr. Pandyan for also having joined us. And also welcome the viewers and the listeners. Mr. Pandyan has very aptly articulated as to how these kind of events at the global level or at the national level have impacted the thinking of the policymakers in lawmaking or taking tough decisions. I don't want to take too much time on that, except to sort of recall some historical events which have really triggered the shift in the insolvency thinking, and then I would try to contextualize that to the situation in hand. As far as the written history or memory of insolvency law development is concerned, we know that the US has always been a leader, or at least had been a leader in thinking, because they're the ones who actually were pioneer in setting up a free market economy when they were building the nation after independence. They had the luxury, much later in history, being a new civilization, if I may say, to really start afresh and not carry any baggage of the past, or unlearn from the past. And that's why, they introduced the whole concept of entrepreneurship, the risk mitigation, and as to the whole concept of second chance, and allow the stigma to be completely disassociated from insolvency from the scratch when they introduced their insolvency law, unlike how the common law countries have always carried a negative connotation to insolvency historically. They are the ones, therefore, introduced the whole concept of diluting the foreclosure law in the times of Great Depression. But I think it was really the World War II which really, for the first time, set UK and, of course, the other Commonwealth countries, and those countries that were impacted by the World Bank II, by the World War II, to really see how insolvency law becomes a very great toolkit in order to sort of help the policymakers to rebuild their nations. And the main reason for that was, as Mr. Pandan also rightly mentioned, that it was not just an economic issue. And these kind of drastic decisions are taken by the nations only when such events impact the life of an ordinary person, when they become when they translate into catastrophe, or when they actually have a huge social implication and not just economic implication. It touched the life of every individual, as we saw during the World War II, when you had cities destroyed, and industrial establishments destroyed. There was no work, people were hungry, and therefore they had to really move as UK after the court committee was set up, even much before that, to that extent, to shift from winding up related law to a rescue related law, something which is inherited by India in the form of an IBC. Now, the other recent initiative in the memory of history would be, at best, Asian financial crisis and the Lehman Brothers. Now, the importance of those, even though they may not have impacted at a global level or the societal level or the cultural level or human level, but what it really introduced as a cultural shift in the thinking of insolvency law was to move the center of gravity of insolvency law towards rescue, towards the entire thinking of restructuring rather than liquidation. And there were a number of experiments done, be it the bad bank ones in Malaysia, Indonesia, Thailand, Korea in particular, an experiment which we replicated in the form of CDR fairly successfully, and something which works very well in Mexico and Chile even today. And this morning I had a call with a very senior policymaker in Singapore, who they're very keen to study our asset reconstruction company system because they don't have any. And at the moment, they are really thinking whether they really need a kind of a vehicle like that. So the thinking essentially happens in terms of what prism do you pick up to look at insolvency law from. The insolvency law would remain, the basic fundamental principles would remain the same, which is to essentially maximize the value of the assets, save jobs, in order to sort of help these assets not get remain locked, unutilized, and keep them productive. And that is what essentially is the essence of thinking of policymakers, which would fundamentally influence the decision making. Now, if you look at it from the prism of today, whether it is India or globally, what is really being thought is as to how do we operationalize businesses? How do we create liquidity? How do we ensure that stabilization happens post the disruption? And how do you make sure that people are sensitive towards the cultural, social, humane side of the law, and look at it holistically rather than just as a hardcore, ruthless economic principle, which is what insolvency law had come about to be seen as in the 5-6 months preceding the lockdown, because Supreme Court judgments were clearly very harsh, something which was being celebrated by many, including the lenders and the government, and something which I was very critical of in my view always, because I felt that we are actually jumping to the other end of spectrum in terms of giving our articulation to how the insolvency law is. Yes, economic aspects are something which are paramount. It is a commercial law, but you can't ignore. And I think that is the thinking which we will have to revisit to put the context to what we were discussing. And whether the discussion around suspension of the provisions, whether the discussion around raising the pecuniary bar from 1 lakh to 1 crore, whether providing respite, whether urging the private sector employers not to terminate the employees, give them salary, all that is coming from that sensitive thinking, where the sensibilities around insolvency law are now going to be very different than what has been seen in the last 5-6 months, which I see as a correction rather than as a reaction.
Yes, sir. Arvind sir, now if you could throw some light on what is the position with respect to ongoing corporate insolvency resolution processes, for us to understand how this lockdown or this period is going to impact the processes that are undergoing right now, and in future, how a pandemic like this is going to bring about a change in the mindset and the outlook of the society as such towards resolution process.
Well, I think I must thank Mr. Batra for filling in whatever I had not said so and very beautifully articulated. I'm quite sure that he will also fill in with whatever I kind of miss out. I'm absolutely sure about that. Now, I'll straight away come to this issue of what happens to pending matters. Even I'm quite skeptical about it, or I would rather use the word, all of us are in the same boat. Maybe you think that I know better is the reason you're asking me. I'm at the same level. But having said that, the one point, at least from my understanding, my humble view would be this 40 clause C, which was introduced, extending the timelines or excluding this COVID lockdown from timelines, has been done in the liquidation regulations. Now, section 12 ensures that a CARP gets completed, or even in the CRP regulations, both put together. The point is, how are we going to read it into the act in section 12? 12 is very clear that 330 days is the time given for the whole process in whatever manner with the last amendments which we had, 180 plus 180, and that 180 plus 90 plus the additional one in any event not to cross 330. Now, does this require an amendment in the main act or not becomes an issue, because these are coming out through the regulations. Maybe the court can say we are reading it down and we would like to fill in the gaps if the court really wants to not look at it too legally. But then the point will be, if they're looking at so much of an amendment to get it notified, bring ordinance or whatever, it is better that they try to bring many of these changes into the main act. So firstly, the pending CRP matters, forgetting for a moment the liquidation. The 330 days, how is it going to be envisaged with this kind of, I would say, the piece of timelines which you're looking at, how to fit into the 330, how to exclude. I personally feel that the whole act requires various tweaking in different places. We are not looking at pre, post or whatever. I feel that this whole scenario requires a complete, if we call IBC as a code, we need a short code within this code only for the COVID at least. I feel there must be a separate chapter for the COVID, starting from the initiation, timelines to complete the CARP, and also pending liquidation matters, and meaning that who qualifies for this also as a 7 or a 9 or a 10. The reason I'm saying so is, firstly, the pending resolution plans completely change in valuation, completely change in terms of business projections. There's going to be a huge difference now. So what those happen, we'll have to wait and see. Is he still going to go ahead and present it before the tribunal if it has been approved by the COC? And if it's pending with the COC, at least we kind of save some time. The second and more important part is going to be, even before you have if you have put up plan, the IBC unfortunately, unlike 230, if you get a scheme of compromise or arrangement approved, 231, which is pari material to 392 of the Companies Act 56, gives a method to modify the scheme. Now, IBC plans do not provide for any amendment or molding at all. I think the time has come for people who have already had plans approved and are working, what they are going to face and how they're going to come. So it's going to be academic to see whether I can take a plan and treat it as an arrangement and compromise and still take it to 392 under Companies Act and try to tweak in. Well, if I do that, I have to call all my class creditors meeting. At least here, I would only suffer the financial creditors. There I have to go for all the class. So they have to think of the existing plans which are working with under the monitoring committee, how they are to be done. The second part is plans not yet approved, what happens? And as lawyers, what we look at, matters pending where CRP has not yet been initiated. Now that's the gray area I'm going to see based on the proposed, the word called suspension, amendments, or whatever we are looking at. Primarily speaking, I think with one or two of the legal precedents which I've seen, particularly the KT Plantations case, where the Supreme Court does give the power to, the Supreme Court does recognize the power of the state to suspend certain provisions in certain situations. Maybe this is a good situation warranted for suspension. But the next question comes whether this is the time to suspend or not. So suspension, I'll park it. The question you posed to me is, what happens to pending CARP? I'm also waiting to see, but I think that the markets should know how to play out rather than the regulator regulating the game. Regulators are there to only frame the rules of the game. I mean, you can't expect RBI to do banking. You can only see RBI regulating the banks, but the banks are the ones who are the players. So the market should be left out to the players themselves to restructure on their own. And I'm quite sure the bankers and the so-called promoters or applicants will be able to work out. At the present moment, to just complete that point which you were asking me, I would think that no doubt the NCLT has the power to approve the plans. Now, the most important thing will be, will they admit a new petition, or is it going to stay still for the so-called timelines which they're looking at? We are all speculating based on the, I would say, the news reports only. I'm keeping my fingers crossed. So pending CARP matter, meaning CARP meaning where it's been initiated, is what all my comments hold good. But for matters which are yet to be heard and admitted, I would typically say they should not be stopped. They should not be stopped. There should be another mechanism how the threshold has already been increased. Maybe they can give the threshold to that. Now, threshold itself having been increased according to me is wrong. A person who has not got 3 lakhs in this threshold is going to go to other forums and create problems anyway. You'll either go to a consumer forum, a RERA, or even a civil suit, or even in some form of criminal action also. So how are they going to plug everything else? It's impossible. IBC alone being plugged is not going to keep these people away. So the present matters pending in NCLT, how to move forward is what we need to see. And how the COVID is an exemption or not, is I'm just throwing it across for debate also.
Sir, what Arvind sir is suggesting is like how the UK and Singapore have done. They brought about certain acts to modify all acts within their country, like the Coronavirus Act in UK and the Pandemic Effect Act in Singapore. I think what sir, I'm in complete confidence with Arvind sir when he says that we need a separate enactment to modify IBC with respect to how COVID is having an impact on the act itself. Sir, Sumant sir, your thoughts on...
Can I just complete that? I'm sorry. What I meant was not a separate act. I thought maybe even a separate part or a chapter into the IBC, tailor-made, like how they amended the Companies Act in Schedule 11. Because in that context, I'm sorry, just for making message.
Ashish, have you unmuted me? Can you hear me?
Yes,
okay,
sir.
Very well. Okay, so Ashish, I have two perspectives from which I would prefer to view how COVID-19 would impact the pending resolution processes or those under implementation. One is the macro and the other is the micro. From a macro point of view, we need to appreciate that IBC doesn't operate in isolation. It has a whole solar system around it. There are a number of laws that orbit around insolvency law. And all of them actually come, close, or leave, depending on what stage IBC, a particular case in IBC is, or what the economic situation in a country is, or what the policymakers are thinking. And that is, so currently, let us assume that in the orbit, there is a planet called COVID-19, which is a complete alien that has come in and it has caused a disruption. And it is bound to obviously compel the policymakers to react at a multiple levels, not just at the IBC level. And all those decisions will have an impact on IBC. Now, for example, if you see the decision to raise the bar from 1 lakh to 1 crore is not an IBC decision. It is a decision to protect the small and medium enterprise from being further impacted. That has influenced the decision, although the amendment has come in the IBC, but it is really to protect those particular segment of the economy. Similarly, the state governments would do a lot to protect jobs, and they would, you will see executive orders being passed, challenges before the labor laws, under the labor laws before the labor authorities on retrenchment, on salaries not being paid in time, FIRs being registered. There will be a protectionist approach by the state governments, local authorities, in order to protect certain constituents. That would also have an indirect impact on IBC, where you would find that such IBC will have to negotiate its way around these kind of external factors. These are macro level factors which are not taken on IBC, but would influence the IBC very heavily. Similarly, the local authorities would take a number of decisions on how certain sector of economies need to be protected or not to be protected, or given priority in terms of opening or not opening. Also, there is a much more macro, larger issue, which is a global issue, which will basically influence the political thinking. Like, for example, the changing shift in the geopolitical powers at the international level, as to which countries' investment would be welcome in the country, which would not be welcome in the country, or which would be looked at with caution or even suspicion. And therefore, that also will impact the thinking of the investors, those companies where investors are being invited. So that's a macro level impact, which is going to cause, which is beyond our control, which IBC will have to really deal with as a larger uncertainty and make very heavy adjustments. Like Supreme Court decisions will also need to be articulated differently, is also another impact, because that is based on the thinking shift that will happen on reconstructing the economy, rebuilding the nation, fresh perspectives and approaches that the various thinkers will bring in. At the micro level, I see three, if I were to prioritize impact, and those are not rocket sciences, not that I'm inventing, or the first one to say the massive disruption it would have caused in the stability or achieving the stability of the CIP processes and management by the IPs and other stakeholders. A lot of effort that would have gone into stabilizing the CIP processes by those people who were appointed or managers of the process, or those who had just taken over, in order for them to achieve stability, is going to be the biggest challenge. That is probably the single most one impact that would really have a trickle down effect, and everything else is really a fall down or a drop down of that. The second, which is also a drop down of that in a way, but of course, which has macro influences, is the valuations. Valuations are going to drop and impact heavily, and it would be naive to think that we'll be able to sort of get back to normalcy, or we'll be able to continue from where we left if we take certain measures. That's never going to happen. Some people will use this to rethink their strategies. Some people will genuinely have problems. Some will also abuse the process in order to sort of use this as an excuse to sort of step back and things like that. Valuation is the second single most challenge in order to achieve resolutions. And I think a lot of decisions will actually depend on that as far as the second is concerned. The third is the shaking of the confidence of the key stakeholders in the insolvency law for this reason, be it the insolvency professional and their future as a career in that, as a future career, the investors, funds that were beginning to set up to invest in the distressed asset space. I would say even lenders who were beginning to gain confidence after some struggle in the IBC. That shaking of the confidence is restoration of that would be a major thing. Now, these are three, in my opinion. If you really were to decipher all these three, at least 50 more will come out in terms of the impact as a result of these three. And these are something which we will have to compartmentalize and deal with systematically, in my opinion. I don't want to trivialize the issue by picking up a particular case or what particular case, be it the force majeure issue or be it the other issues. These are all fallback or drop down of these three issues.
What I think it was beautifully highlighted and pointed out that IBC is only the pinnacle of the mountain, wherein any amendment that is sought to be brought in the laws would have to flow down to every which law which operates in the country so as to give effect for implementation of IBC as such. So
also it could be the other way around as well, Ashish. It's not just that the thinking will be triggered through IBC. IBC will not be the catalyst necessarily. The catalyst would be the policymakers operating in different space and taking decisions there, and those getting implemented or impacted in the IBC. So IBC is not going to be the driving seat in that sense. The wheel is not in the control of IBC anymore, as was in the last 3 years. The policymakers will, those sitting behind the steering wheel are going to be the PMO, having a larger strategy for the nation in place.
Arvind sir, your thoughts on this, because what transpires from Sumant sir's thought process is this, that if you are looking to look at IBC, how we have looked at it for the past 2.5, 3 years, it's going to be completely wrong. And the GOI and the ministry will have to take effective steps to bring about consolidated change in all the laws so that we are able to achieve the end of IBC.
Yes, I would surely. I'll just break this into 2 points. I'll just continue from where Mr. Batra had just left. He made a very nice point by saying that this is not just going to be a national issue. It would also depend on various states or the regional players taking their own respective decisions also. In fact, coincidentally, since I'm also a law officer of the state as an additional advocate general for the last 6-7 years, I do get into knowledge of what the government does now and then. So in regard to an offshoot maybe of the topic what we're discussing in the context of what Mr. Batra mentioned, the state government also on 29/4 has brought about a GO constituting a special investment promotion task force, which consists of 12 members headed by the chief secretary and the finance secretary as additional chief secretary, who is number 2, and then the industry secretary and the commissioner of commercial taxes. Now, the interesting part is apart from these 4, the remaining 8 are going to be from representatives of US, South Korea, Japan, Taiwan, and Singapore. Now, each one is going to have based on their expertise also. In fact, it doesn't just allow an nominee based on the country or nationality. It has based on their expertise. One for Japanese industrial parks, Japanese companies per se, Korean companies per se, then one chamber of commerce from the US and Korea, and then from the US companies per se and Taiwanese representatives. So they're breaking it, and the context itself was how to attract and bring the investors, and the mandate given is to do it in 2 months. Now, when these investors come, many of them maybe would be relocating or maybe starting afresh or so, find new opportunities. And one category is the candidates like what me and Mr. Batra are trying to address. Are there any existing businesses on which they could exponentially look at growing faster rather than going at a embryonic stage? Can they just go for escalation? Now, that is an understanding from our state's perspective is what I'm saying. So like this, each state is going to have their own wherewithal to bring about. This is just a mechanism what I talked about. Mr. Batra just impressed upon also the other state legislations. Take, for example, the Local Shops and Establishment Act or the Factories Act or the Employee Welfare. Now you need to protect employees and you should continue to pay. How far is it going to be? A lot of other peripheral laws also which are concerned in this particular situation. Now that's why I always actually like this word called disruption. Carl Jung says, in every disorder, there is a secret order. Now, what all we have kind of faced now could virtually be quote unquote a new order. So that way, I completely agree with Mr. Batra. We have to unlearn a lot of things, what we have seen till now. Now, the concept of insolvency or liquidation has to be taken away from our mind that it is because they didn't have money or have done badly. Now, this is a force majeure situation which has brought about equivalent to insolvency or leading to a liquidation. The President of the United States gave 4 times, but he's still the president now. After that, he's come back every time and he become. Again, I'm not comparing US here. They were able to do that and still come back. In our country, like how we have a COVID patient, is it a kind of a stigma or not is another issue. But this particular situation, I am also of the same view that we should not see the same concept of insolvency, bankruptcy, or liquidation, the same understanding of how we saw it earlier. The deemed unable to pay is this, the word called default. The default now has a different concept totally now. So this is the only law in the country right now giving a moratorium of 180 days. Rather than looking at a longer moratorium, we should not try to, that's maybe my own personal view, that my suggestion would be try to elongate the moratorium and give these players some breathing time and to talk to the stakeholders and bring about. Rather than that, trying to shut shop of this and saying that nobody can go into it. It's like putting everything in a genie box and suddenly it opens and it bursts totally after some particular time. You can't. You rather allow the vapors to slowly evaporate and ultimately you'll find what is the residue at the bottom of the box or the bottle. So instead of that, I fully agree that we need to tailor make depending upon the industry, the region, the culture, the economic requirement of that particular state or the region is what I would also like to advocate.
So therefore, the 3 pillars of probably a CARP process being the corporate debtor, the resolution applicant, and the COC members who are sitting and who are in charge of keeping the boat afloat. I think the policymakers are now required to come out with solutions to use this pandemic and give effect to the ultimate essence of IBC, which is nothing but restructuring. Only the yes, sir. The act was brought into force only to restructure.
I would again, I'm telling you, I'm taking the words out of Mr. Batra's mouth. We should try to unlearn from the earlier experience. If you said right now there were 3 stakeholders: the corporate debtor, the financial or the creditors, whoever, and the third one you mentioned is the resolution applicant. I would like to replace it with a word called promoter also. Right now, this is not his own making. It is a making of the nature or in whatever way we may call it. Has our lockdown been warranted or not? 1 year down the line, somebody may completely criticize how many deaths did we have. People always try to postmortem after the event. But I don't think the government is wrong at all in taking whatever decision because at the moment, what they thought best, they've done. So the promoters is also a stakeholder in this, which I will address it later when I come in regard to context of 29A. So keep the resolution applicant who should not try to benefit out of this pandemic. I do not want somebody coming in and trying to snatch out of a good promoter or good management, a kind of a candidate which was running till now like a blue chip or some kind of a gem which others were watching. Let's take a chain of stores or a chain of hotels who are running small restaurants and suddenly they're not able to have any business and they're just shut shop. But the brand name was such a big one earlier. Think of people like them. Do they need a resolution applicant? No. So the stakeholders, I would like to expand the word called resolution applicant, if not substitute or replace, or I would say oblique at the word promoters also. Sorry, I just wanted to add that.
No, but that's a very good point made by Mr. Pandyan, and I endorse that. And I think this is something which one requires a standalone discussion in terms to bringing the attention back on the promoter. In my perspective, besides the stakeholder that you mentioned, I think there are two other stakeholders which really need to sit at the top of the iceberg. One is the economy, the other is the society. I think every decision in every case has to be keeping in mind that our biggest objective goal as a nation is to salvage the damage it has caused to the economy. And therefore, whatever needs to be done keeping in mind the efforts that are needed or the decisions that are needed to sort of protect our economy. The second is the psychological impact or the other impact on the society, be it the employees, be it the anxiety that has caused to various people, which has a deep, deep impact on how we function as a civil society, how people behave, their conduct, their behavior, their mental health. All that as a society, as a collective society, is a national responsibility as well. So we also have to start looking at these two stakeholders in all our decision making, and not just look at getting money back for the lenders only. And that is, I think, a very, very important two stakeholders.
Now there is one particular issue that bothers me. There was great pompous about home buyers being protected under the insolvency and bankruptcy code. Now they've introduced certain sections which bring about regulations with respect to how home buyers can approach under IBC and seek certain reliefs. What is your thoughts on bringing or permitting home buyers to seek relief under IBC? Is it even right? Is this the right approach for a home buyer to come forward and seek for resolution of a company? Your thoughts on this particular aspect of IBC?
You're asking me.
Who's this? Yeah.
I'll start with the Arvind sir, and then I will move on to Suman sir.
Sorry, Mr. Batra.
No, please go ahead. Please go ahead. I was only asking who's the question addressed to. Yes.
So all these, it's become a law. They've introduced it. No doubt it's in Supreme Court. Supreme Court has not stated, given a status quo in regard to pending matters, keeping the qualification without it. So I'm quite sure that that is one class which required some protection. Personally speaking, left to myself, it's a commercial wisdom only, and it doesn't have any legal wisdom to say whether a home buyer is a creditor or not. In fact, in Companies Act, whenever you did a scheme under 230 to 232 in the new act, and it was 391 to 394, except for one or two decisions, they kept the FD holders or the deposit holders out of the context of the word creditor, even though it didn't mean so in 391 as it stood then as word creditor. 58A, which was for the deposits, which was equal to 45 QA of the RBI Act. 58A depositors were persons who deposit money in the company, but 45 QA was for NBFCs. Now, RBI Act it was overriding the Companies Act. So the Supreme Court said you can never frame a scheme in the case of an NBFC. So again, how the law meant for a particular class is what it means. Left to myself, I think with the present threshold, it looks quite beneficial both for the promoter and the home buyer. Earlier, there was not even a threshold. A single rogue, I would say a home buyer who was just booking and trying to arm twist the promoter, and which was really happening also, which I have in my experience seen, ended up in some kind of CRPs being initiated also. But now with a threshold, at least they have kind of plugged it. But personally left at, not being a regulator, I don't think I want to comment on whether it's required or not. But from a home buyer's point of view, I think it helps them better to come far. RERA alone will not give them RERA will give them the benefits, I would say, of whatever has not been given there, or will entitle them to have the flat as such within a particular period of time. But again, that order, how far the only thing is the promoter will not be able to do future projects and affects him business wise. But this legislation threatens their existence. So that is the fear. I mean, Indians have never worked unless their existence were put in threat. Until the suits were on, you can go and file a suit. What can you do? In 93, when the DRT came, all the banks were gung-ho. Oh, we have a separate legislation. Let's go and collect. They couldn't collect for 7 years. And in 2002, we had to bring the Securitization Act. So I won't have any court intervention. I'll be able to recover my property. Again, Securitization Act never kind of gave that. So the problem is with us and not with the regulator. They tried giving us opportunity at every time, either as a borrower or as in some manner a stakeholder. We never respected the law. But the moment IBC came and said, for this default, you'll be killed, that's when the typical Indian sense, immediately we jumped up. One group was against it, one group was not against it. So the whole, I would say the real estate lobby jumped up when the home buyer definition came in for this purpose. Now I think they should be a little bit relaxing or a kind of a breather if the threshold is there. I personally, to conclude on this topic, would say that you should keep the home buyer here, at least knowing the Indian mentality.
Speaking for myself, Ashish, without going into the merits or demerits of giving those rights to home buyers, the need of the time is to bring the focus back on the infrastructure. You see, that's one of the biggest engines that drive the Indian GDP and economy. You have migrant laborers who were trapped, still trapped in a number of cities, who were working in these big establishments, construction sites. They will not come back. And if they have to be brought back, they have to be given certainty that, the plant will again not shut because of insolvencies and things like that. So I think from a greater certainty point of view in real estate sector and other infrastructure sector, we need to probably have greater constraints on going to IBC or doing anything that would disrupt if we resume work on the construction sites. So I think we need to have a larger picture in mind at this point in time. And maybe 5 years or 10 years from now, one can revisit the situation. But I think for the next 5 to 10 years, we are in for better ecosystem for infrastructure to operate in, so that economy can get an engine or injection of boost.
So now, with respect to resolution applicants, we have seen from our experience over the past 2.5 to 3 years from the time the code has come to being, that they have not had a rosy part, since they have faced cash crunches. They have been saddled with liability which the erstwhile promoters incurred, and government bodies came after the resolution applicants to recover their dues. Do you think enough confidence is bestowed by IBC on resolution applicants, or the policymakers need to do more on that front? So I'll start with Arvind, sir.
I'll just add, like how I was mentioning, well, again, using the word disruption, the word resolution applicant has two meanings. The resolution applicant pre-pandemic was in regard to stressed assets, basically, when the management was not able to have its, I would say, the financial mismatch or business reasons or whatever. And so a resolution applicant found that there is value in this business where he can bring in some additional value or create value if he takes over. That was purely a commercial call. But a resolution applicant in the present situation, again, I'm stressing, is he a person who's going to kind of profit out of somebody else's misfortune, is what I feel. So the context of a resolution applicant now post-pandemic, whether it is a pending CRP matter or one in case if it's not banned completely or I would say barred completely, how it is going to be changes. I actually think the most important role, depending upon the changes which are going to be brought, will be by this so-called resolution applicants. I think what they should consider, which my suggestion is instead of completely barring 7, 9, and 10 is an I would say, a non-negotiable one. They shouldn't even look at 10. They could bring in amendments in 7 or 9 to ensure that the new category of default, how it has to be, can be redefined or whatever. But in any event, what I'm trying to suggest as a overall at a macro view, subject to what Mr. Batra also feels, 29A requires a huge relook in the present situation. Maybe I would have agreed with 29A in the earlier scenario to an extent, not completely. We should not allow somebody in the society as well as in the industry, if he's completely violating the law or creating fraud, diversion, or whatever, if it falls as a criminal offense. But if the business has gone down for some reason, why should the promoters be stopped? I would typically say that I don't agree with SEBI's action about 2 months back when the markets fell down completely. They banned all the promoters from going and buying in the markets till June 30th. Now that's a wrong one. If promoter has seen value in his business and wants to consolidate, he has faith in his, I would say, the business what he's running. Nothing stops from him from buying to consolidate, which takeover code consolidation of holding up to 5% is given. Rather, lately they brought about a amendment, rather say notification where the neighbors could not come and buy, meaning the cross-border neighbors. Now that at least is fine, you're protecting, but nothing stops from the promoter or the Indian investor to buy. It is the same analogy I'm trying to draw here. The 29A, I think, requires a relook. That is where I think they should tweak in and allow it rather than looking at keeping the whole IBC into hold. So the resolution applicant concept should be, I think, revisited by not allowing a white knight, as what we call usually, to come and try to help them. Rather, not allow a promoter to take a poison pill is my view.
Well, I do agree by and large with what Mr. Pani said, so I won't repeat that. My personal take on is slightly from a different perspective, and is that I feel that you see, suspending the IBC is not a good decision any which ways, because it has taken a huge effort to bring IBC to the stage where it is today. 3 years of government might has been put behind it. Massive energy, a massive cost has been spent. We have created aspirations for people. There is a lot that has been invested in the IBC as an industry. We should not undo that, because the message that will go out of this is going to be in an intangible way more damaging than the tangible damage it will cause. To recommence it and restart it is going to be a massive challenge. People would have moved away, alternate practices would have started, investors would have put in their money elsewhere. It's not going to be easy. I do feel that Section 9 is something which could be temporarily suspended, because Section 7 would also be invoked by lenders only when they have a trust deficit with the promoters and they know that there is no hope, expectation of a resolution with the current promoters, because there is a lot of bad blood, right? And the promoter would continue to probably, buy time and yet not there be a resolution, and or maybe where there are frauds or allegations of money mismanagement, at least the lenders should not be without a remedy. The Section 10 should be an enabling provision for those promoters who genuinely feel that they are helpless, they have nowhere else to go, they need a platform or a mechanism or an avenue or a resolution process, and therefore Section 10 allows them to go forward and at least then collectively with other stakeholders keep the value of the business alive, because they themselves are unable to do that. Section 9 is something which probably has the probability of abuse, because someone with 1.5 crore, a small investor or a small disgruntled supplier can really cause a good damage. So I feel that if at all anything, Section 9 should be suspended and nothing else. The next observation that I have is that I think the government will have to simultaneously invest on building the out-of-court restructuring mechanism, which works very strongly and efficiently in other countries in developed economies. It runs as almost in parallel to the formal mechanism. We've had an excellent RBI mechanism, which obviously had its own flaws. which still continues to have some flaws. And I think June 2017 circular, the Sashast scheme of the government, and probably now with the government considering the pre-packs as a hybrid of the two. Now this is where the attention should come, because Mr. Pandyan's points get addressed there, because you have the promoters then driving the resolution. And if they want to bring in an investor, they bring an investor of their choice. So they are no strangers in the bed. You have investors which have harmony with the promoters, who have negotiated and they are able to work together. And they bring the lenders on board as well. So that is how I think the opportunity at this point of time has to be utilized in order to not sideline the promoters, but bring them on board. 29A dilution is going to be a major policy challenge decision to dilute. I don't think the government is going to do that. It's a huge face-saving issue for them as well. So probably, it is the best is that we invest in Section 12A, out-of-court restructuring. Pre-pack may be brought in. But yes, if at all the government gathers the courage to take the 29A down, then it should be diluted significantly, and probably willful defaulters or some of the other two categories can be retained, and the rest should really be unleashed in that sense.
We are almost out of time. So what I understand is that IBC is a banyan tree, and the roots of IBC in India are just starting to sow in. At this point of time, if the policymakers are going to meddle a little too much, then we will see probably IBC also fade away like any other law. And like Mr. Sumant had put it, that it has taken a lot of effort for this code to come into force. After a lot of trial and error, after failing many a times, we have got an IBC in force, and we are seeing some light in the tunnel. It is.
Yes, Ashish, can I make one point? I'm sorry, I'm interrupting you. I just want to make my last observation. Of course, if there are any questions that I'll answer. Sometimes the mistake that we end up committing is that, when things are beginning to get put behind us, like for example now, imagine how we were on 27th or 28th of March, or when the lockdown was extended in the second round. But today we see, we become so used to all this, and we see, okay, fine. At the end of the day, we are still going back to office. And the mistake that we end up committing then is that we look for continuity. We want to start from where we left, and we want to achieve status quo ante. That is a mistake we should not commit. That is to try and achieve status quo ante. We should really look at this as an opportunity which has caused a major disruption and will continue to, and we should try and reinvent ourselves, take very courageous decisions, including some of which we have discussed, including on 29A. And this out-of-box thinking is what will bring us out, and not an attempt to get back continuity in a typical sense and try and go back to the point where we actually shut down on 23rd of March or 24th of March. That, I think, is what real policy making should be all about at this stage. And also decisions of the various thinkers in the insolvency industry.
Arvind sir, you wanted to say?
Yeah, so sorry. It was completely on a different topic, because I'm fully in agreement with whatever Mr. Batra has mentioned. Now, two other points which I asked as a question, which I just wanted to answer directly was, one was what happens to the personal insolvency side. Now, I do not want to touch upon it because even the government did not want to bite the bullet by notifying Part 3 so easily, even in the prevailing circumstances. But they thought fit not to do so till then. So that's still going to be a gray area, how individual insolvency is going to still play out. It will still go with our Presidential Insolvency Act so far as the state goes. That was one thing which I wanted to make. Now, assuming there's another question which I just wanted to put in. Section 7, 9 and 10 resumes and a company is dragged into insolvency. Is there a chance that directors can be held liable for wrongful trading for procuring loans and the like attempts to finance their companies to recoup, as we have not suspended wrongful trading provision? Now, frankly speaking, that is only a factual situation. if you have really raised money in the context of what Mr. Batra and myself have been able to say, that today somebody trying to run their business is doing it. It's like what Jack Ma said yesterday. If somebody is able to be alive today and not think of profit or dividends, then he has already made a profit. So I'm quite sure that NCLT and its members, with their wisdom acquired in the last 3 years in regard to wrongful avoidance, preferential and exorbitant transactions being looked, it is on a case-to-case basis that they will look at it. So we really don't need to worry about that for the moment as to how money being raised. Is it being raised for the sake of a losing business? I mean, it should be so stark for the NCLT to come up. So I don't think they should actually suspend wrongful transactions provision at all, or rather anything above 40 or 42 to 52, 51 effectively. I don't think they should consider that at all. That is more required also because some past may come out also. So we are, as he said, I also advocate that completely. We are now in a new learning process. Let's kind of engage with it, absorb it. And you mentioned IBC as a wonderful tree, which is called the banyan tree. In Indian mythology, banyan trees are the place where ghosts go and hide. Now, I would say if IBC is a kind of a banyan tree, the ghosts also are scared of the banyan tree and they still live there. So I typically would like to leave. Let's not be fearful of the ghost. Let's enjoy the banyan tree shade as well as also the law assets. I think that's my closing comment.
Yes, Suman sir, would you like to add in on this? Probably on the banyan.
On the banyan tree. Oh no, I completely agree. I mean, he's said it so well. I don't think I can add anything to that. I just want to make a comment on the personal insolvency law. Yes, I have been, I was a member of I am a member of the working group of the IBBI on this, and for the last 2 years, I have been the one who has been able to persuade the government to not implement it. I've put my foot down. I have recommended many changes in the law. And I've said that without those, you cannot implement. Although they have implemented it to some extent when they are amended the law to create these categories, 3 categories of individuals. One of the personal guarantors, and those personal guarantors part obviously it has been implemented, which to some extent was livable as a decision. But again, the difficulty is that they suspend these 7, 9, 10 provisions. They will also have to suspend those provisions because how can you have CIRP not proceeding against enterprise, but you going after the guarantor or the main promoters who would then be engaged in the energy, focus, attention in managing the personal insolvency rather than stabilizing the business. So that would be so contradictory. And I think the government would be, and I suspect that these are some of the reasons why the ordinance has not been passed so far. In spite of the fact that the cabinet cleared it on 22nd, it has taken them 10 days, 9 days. They haven't decided because I think they are having rethinking on the whole scenario. And thankfully, they would take a wise decision. Hopefully.
And it's been an absolute pleasure listening to the both of you. And I'm sure myself and all the audience today are going back home a little bit wiser with your thoughts. And we will wait and see how IBC plays out. Kalyan sir, if you could
Sir,
your thoughts on.
We thank you all. As the year itself says, it is a year 2020, and the 5-day test match having become a 2020 match. I think the pandemic has forced everyone to take decisions in a very urgent manner, to live with the changed norms, whether it is the government, whether it is individuals, whether it is organizations, all have lived up to the expectations. There will be a lot of heartburn, there will be a lot of churning, but I think, as they rightly said, with enough checks and balances, more from a society point of view, it should be a mindset change. As Arvind Pandyan sir rightly said, it should not be the white knight coming, or it should not be a person just wanting to knock off something. At the same time, it should not be that people are able to take the system for a ride, which used to happen earlier. It's a mindset change. And with the 2020, the speed with which the governments have worked, whether it has been at the center or the states all over India, I'm sure we all as professionals and the business community would definitely have a lot of challenges. And I think we should be able to come out of it successfully through. Thank you all. Thank you once again, Mr. Arvind Pandyan sir and Mr. Suman Batra, for the wonderful insights which you have given.
Pleasure.
Our pleasure. Thank you, Mr. Suma.
Into this.
Thank you,
Thank you, sir.
Thank you, sir. Thank you so much. Thank you so much.
Thank
Thank all the audience for participating. Thank you so much.
Thank you.